I want to say welcome back, everybody. Hope you just have enjoyed the morning and afternoon. It has been wonderful. It's been a long day, though, I know. And this is our last panel, and it's just as exciting as the prior one. So I want to introduce our panelists, and we'll start shortly. So we have Justin Elliott, who is joining us. He's a reporter with ProPublica since 2012, and just this past May, congratulations, ProPublica won the Pulitzer Award for his coverage with others about the Supreme Court Justice Clarence Thomas's undisclosed trips. He has been he has really been an amazing contributor to not just the disclosures or reporting on Justice Thomas, but on other Supreme Court matters, as well as other topics about governance. He was part of a team of reporters entitled The Secret IRS Files. He's also worked on Intuit settlement. So he has covered a wide range, I will say, of court matters, not necessarily just court people. So welcome, Justin. I also want to thank you. Sorry about that. I also want to welcome Judge Cynthia Rufe. She has been on our program before, so I want to thank you for returning. She is currently a senior judge in the Eastern District of Pennsylvania Federal Court, but previously she was a state court judge. She was a public defender, and she was the past president of the Independent Federal Judges Association. As you will hear, judges are limited in what they can say and comment on, but as president of the Independent Federal Judges Association, she did speak out on behalf of judges and the importance of their independence, and as well as protecting their security. And then our last panelist is Russell Wheeler. He is currently a non-resident senior fellow in the Brookings Institution's Governance Studies program. He is bringing an amazing wealth of knowledge, or in my mind, an expertise to this field, because he was served the Federal Judicial Center as a deputy director, and he was on the senior staff associate at the National Center for State Courts. So he has a breadth of knowledge of federal and state court and judiciary I'll say requirements and limitations. So I want to thank you all for joining us on this panel.
Thank you.
Thanks. So I think, Russ, why don't we start off with, I guess, a primer, right, on what are the limitations on judges and judicial conduct and disability.
Well, thank you. It's good to be here. I like to put these in two buckets. There are some policies which main goal is to help judges stay out of trouble, and other policies to deal with allegations of misconduct or performance degrading disability when they occur. In that first bucket, helping judges avoid trouble, obviously are codes of conduct. Every state has a judicial code of conduct, as does the federal system, stemmed out of the ABA's model code. And they vary. Some codes of conduct have mandatory elements to them. Some are purely advisory. Some mix them both. And all the states and the federal also have advisory committees. So a judge who's weighing a particular action and is not sure whether or not it violates the code can contact an advisory committee and get guidance from the committee about whether or not to proceed. Second, there are limitations on outside income and reporting requirements, which grew largely out of the Watergate era. Requirements for example, federal judges annually, along with other high officials of the government, annually to report income and gifts and outside employment of themselves and also their spouses and immediate family members. And these go along with some limitations on income judges can accept. For example, federal judges are not entitled to accept honoraria for giving speeches or articles. Congress made that deal in 1989, no honoraria, but will provide you an annual cost of living increase. They kept the first part of the bargain, but not the second part of the bargain. Then there are disqualification statutes which tell judges something they should know already, but spell out times in which they should not sit on a case because there may be a conflict of interest. Even in general, or then laying out specific instances in which judges should not participate on cases, when they should recuse themselves. And then finally, and this is probably the most pervasive form of helping judges avoid trouble, is informal counseling, the kind of counseling that goes on not in the public eye because there's a complaint filed, but when a judge perhaps is edging towards improper behavior, or perhaps a judge is reaching the point where he or she should retire. These informal sessions kick in with a chief judge. Judge Rufe, I imagine as chief district judge, had that own experience herself in dealing with colleagues, or is certainly aware of it. But this is not very well publicized, and the judge's response is, if we publicize it, it wouldn't work. So those are four things basically to help judges stay out of trouble. Then there are a few policies which deal with allegations of misconduct, and of course they presumably have a deterrent effect as well. There are civil and criminal prosecutions. Federal judges, state and federal judges, are sometimes prosecuted or the objects of civil suits, sometimes for behavior on the bench. There was an unpleasant incident in Pennsylvania a couple of years ago. Judges who were taking paybacks for sending juveniles to certain confinement areas. There is legislative impeachment and removal, which is very rarely used, 11 times in the history of the federal courts, for example, and not much more in the states. It's a very cumbersome and bulky process. It does, however, have a deterrent effect. There was, in the last 4 or 5 years, 2 federal judges, one in Alabama, one in Alaska, resigned from the bench because they surely would have faced impeachment in the House of Representatives had they not done so. So impeachment and removal is sort of like it's a nuclear bomb. You don't use it very often, but it has a deterrent effect. And finally, there are disciplinary systems. Every state has, as the federal government, a system for filing and acting on complaints alleging judicial misconduct or disability affecting a judge's capacity to perform properly. And they exist in the federal courts and in the state courts. They came about basically in the 1970s. There are, however, differences between the federal and state systems. I'll just mention 3. One is the agencies in the states almost always include laypersons, legislators, lower court judges, and appellate judges. Second, in the states, in the state systems, the disciplinary mechanism can reach all the way to the Supreme Court. In the federal courts, as we've heard quite extensively because of some of the problems of some of the justices, the disciplinary mechanism does not reach the Supreme Court. So there's no way one can formally file a complaint alleging misconduct on the part of a Supreme Court justice. And finally, the states tend to be a lot more transparent when the disciplinary procedures become public. In the federal court system, with some exceptions, the fact of a disciplinary proceeding and the judge being disciplined doesn't become public unless there's a public censure imposed on the judge. In the states, most of the states, as in Pennsylvania, open up the disciplinary proceeding once a formal investigation is begun. I should say almost all the complaints filed in the federal system and the state system are dismissed pretty early because a lot of them are just collateral attacks on decisions of judges, and they either frivolous or they relate to the merits of a decision. So that's a real quick summary, Debbie, of the various mechanisms that are available in the states. We can obviously get into more details to the degree you want to do that.
Thank you very much. And Judge Rufe, I guess how do these rules impact you? Because I know they do.
They definitely do. I was making a list just to be sure I didn't exclude anything mistakenly. And there are a series of annual and periodic reports that we must make in all things. And they have to do with those 2 buckets that Russ was just describing. But we'll do the finances first. This is Court Ethics and Transparency Act of 2022 added to the annual financial disclosure report that we already had to file. And I found when I came here from the state court as a judge there, a similar report, although there were some very distinct differences. And in the federal system, they wanted to know all about your acquisitions and divestments of securities and assets and things that, other than mortgages on your home, you really had to tell them more than in the state reporting system. On the other hand, you didn't have to put down a car loan or a mortgage like you did, at least when I was a state judge in the state system. What the federal system does instead is have additional periodic reports on financial transactions. And this is for certain classes of securities within 30 to 45 days of the transaction, not annually, 30 to 45 days. So you have to do it on both reports. But this came from the Stock Act, the most recent Transparency Compliance Act, and it's onerous. You have to file a quarterly report to say you didn't have any transactions. But when you do have a transaction, you must report it within 30 to 45 days. Where does this lead to? It leads to litigants and the public and the press, because they do request our reports, very often request our reports. They want to know if you're sitting on a case where one of the parties is an entity that you hold stock for or have a personal interest in. So there's a purpose for these, but it is very detailed. And I will tell you that it is important that federal judges, Article 3 and Article 1, just have to report this, not the justices of the Supreme Court. Russ already introduced that. This isn't for them. And then there's all other kinds of non-case related financial reimbursement annual reports. If you go to a bar association function, not only do you put it on your financial disclosure report annually, you have to tell everybody how much you were reimbursed to attend an ABA convention, even if you're working there. I say working because when I attend a bar association or a lawyer's or judge's conference, I'm usually speaking at it, or I don't take the reimbursement. So it's very interesting. Even my Federal Judges Association meetings, I have to put on those reports because it's associated with law, but it's non-case related. So in addition to that, there's all kinds of rules about judicial conduct and disability. We can probably talk about that in a little bit, but there are many, many times where we have to report, and always financial transactions. Then there's this whole conflict and recusal list that has to be public. And I'm not complaining about it. It doesn't bother me at all. But we maintain this list for several purposes. One, so that parties, if they're assigned your case, will know whether you should maybe think about recusing. Maybe the other party doesn't want you to recuse, whatever it is. Do you have to recuse when you own stock in a party? Probably. Most times, yes. If it's a parent company stock and it's a subsidiary, or the reverse, it depends. There's lists of charts that we are provided with from the administrative offices and the judicial conference committees that are really helpful in saying, when do we report this? Do we have to report this? Yes, yes, no, no. Because it's quite a long page of transactions and acquisitions and divestments that we can get caught up in trouble. And sometimes, because recusals for conflicts are up to the judge, there are guidelines that don't make it a question, but many times it's a gray area. So it's very helpful to have committees that you can turn to for some advice, and helpful that you don't try to do it alone and say, oh, I'm fair and impartial. I'm never going to rule for my insurance agency just because they're my insurance agency. I wouldn't do that. And it's true that many judges cannot keep recusing for everything, because then who's going to get the case? And on appellate courts, maybe on 3-judge panels, that doesn't matter. They can switch the panels. It doesn't apply to the Supreme Court, so it doesn't make much difference there. But to us, I'm a lone wolf. I make my own decisions. So I have to be pristine, in my opinion, about having no connections to parties. And that's why I keep a conflict list, and I have for years, even though before it was a requirement. So, and there's more, but we can stop there because Deb has a lot more questions.
But there's even more than that, because it's not just pertaining to you, right, and your finances, but it pertains to, you know, your former your husband and his finances and your joint finances. So, you know, would you want to touch upon that a little bit?
I do, because there are some judges that came that did not care to disclose their husband's finances, and they didn't, and they didn't get in trouble for it because they said we handle these things separately. I suppose if you're set up like that, that's fine. I balked because I didn't want to be involved in my husband's stock transfers. I didn't care about it and wasn't my thing, but I was still reporting it. And I had to get a specific power of attorney from his stock brokerage just to be able to see a report. And then when the transactions became 30 to 45 day reportable, I had to. But unfortunately, that was in the decline of my husband, who has since passed, and it's not an issue anymore for me. And I still feel that it's important when you're living in a close situation and somebody else has an interest in one of your parties, it probably is a good idea to not have that case. There are plenty of other good judges that can handle that case and avoid that particular pitfall. But just this morning, I read about a colleague in Ohio who recused, and he did so even though the parties were conflicted about it. It's a big case. It's a Dow Chemical case, and it's Judge Dan Polster. And he didn't have to, but he thought it was best to do that given the appearance of impropriety being avoided.
And so that's, I'm going to interrupt you for 1 second, because that
Go ahead.
appearance of impropriety language is really crucial. Is subjective, but it is something which, you know, I can't emphasize enough, is really crucial. And I'm going to pivot and go to Justin, because that appearance of impropriety is what you and your reporting, I'll say, you know, discovered or disclosed. And, you know, I'm curious as to what motivated you, right, first to start your reporting on justices, and you know, did you study, did you learn about what the Article 3 judges had to, you know, the rules that they had to comply with it before even starting your investigation?
Yeah. So the answer to that question is no. I had no idea what the rules were. And in fact, when my colleague Josh Kaplan and I started doing what ended up being this reporting about the Supreme Court, we didn't have any sources in the judiciary. We didn't really have any story ideas. We have, despite the fact that I'm in front of a bunch of law books, I have no legal training. For some reason, these are just at ProPublica's office. No one ever looks at them. No, but we originally, you know, about 1.5 years ago, Josh and I were sort of in the phase that I'm sure all the reporters on the call are familiar with, the phase of the kind of journalistic cycle where you're looking for a new story. And we had this broad idea that the judiciary at large, not below the Supreme Court level actually, was, you know, relatively undercovered outside of the kind of legal trade press. And our original idea was that we thought we were going to write about the appellate courts, where there was a lot of interesting decisions happening and, you know, maybe arguably not getting enough attention. But in the early stages of poking around, a few of the experts that we were talking to had brought up the circumstances in which Justice Antonin Scalia had died, several years ago, back in 2016 now, and a lot of people remember that Justice Scalia died unexpectedly in his sleep, but he wasn't in Washington. He was at a private hunting ranch in Texas, and there was some stories after this happened, because he happened to pass away there, about the owner of that ranch having been involved in a case of the Supreme Court, or maybe it was just a cert petition, and wondering what this relationship was. So that got us thinking about a kind of basic question, which is, who has access to the justices, some of the most powerful people in the government, when they're not at the court, in oral arguments. And, one of the early breakthroughs that led us to dig into this more relates to the public records terrain when it comes to the courts, which I think is useful for everyone to know about. And so what we realized, I've covered the executive branch a lot, and when you're covering like the Department of the Treasury, you can file public records requests for a lot of different documents. You can look at the Treasury Secretary's calendar, which is just posted on the website. And if you're covering Congress, you can look up campaign finance records, lobbying records, and so forth. What we realized quickly when we started looking for these things for the Supreme Court is that, first of all, Congress, when it created the Federal Public Records Law, the Freedom of Information Act, in its wisdom, exempted two parts of the government from FOIA. One was Congress itself, and the other was the judiciary. So there is no FOIA when it comes to the federal courts. So you can't just write a little request and say, give me this stuff. They won't give it to you. But, as we got, by the way, just a side note, that's actually not true for all states. There are, I think, some states. I was
just going to interrupt you. Pennsylvania has it, but there's certain limitations, but Pennsylvania does, yes.
Right. So that's something that's probably underused by reporters. So one of the early breakthroughs in the reporting was when we were thinking about, okay, if we can't, and at this point we hadn't decided to do a big project or anything like that. We were just poking around, but we were wondering, like, what kind of information can we get about the justices' travel? And we realized that when the justices travel outside of DC, sometimes they have security. They have the option of having security provided to them by the U.S. Marshals Service, which is, it turns out, just by a kind of quirk of the bureaucracy, is not part of the judiciary. It's actually part of the Justice Department, which is the executive branch, which means that it is subject to FOIA. And so we were able to get a big stack of, highly redacted, but U.S. Marshals records. They were actually kind of budget requests internally at the Marshals for when they had to do these special security details. And we were looking through those, and actually, if I can share my screen, I can show you what it looks like. I think I can. Tell me if that's working.
Yes.
Okay, so this is what it looked like. This is one page out of 500 or something. And we started to notice, and the red arrow is added by me. But as we were looking through these, and by the way, for people that have not looked at FOIA documents before, the redactions where it says like B6, B7, those refer to the different exemptions in the law. So, one of them is like personal privacy, and there's a security one, et cetera. So you can see this document is talking about a justice who is not named, that's redacted, traveling from Dulles Airport to New Haven. But the thing that jumped out at us was that this was on a private plane, and we started to see references to private planes. And through a bunch of other reporting, which I won't get into right now, we were able to, we realized that, this trip, for example, was Justice Thomas, and it was on a plane of this Dallas political donor and billionaire named Harlan Crow. And that seemed interesting to us, if justices are being, or any public official, frankly, is being kind of ferried around on private planes. Like this trip, for example, from DC to New Haven, which is not very far, but if you take a private jet, this particular type of private jet, you might be paying $50,000 or $60,000 round trip, so they're not cheap. So that struck us as interesting, and then we decided to sort of dig more into it, and but that was the beginning. And so I guess the last point I'll make on the public records front is, and this I think is true even when you're not writing about the judiciary, even if you live in a state where the judiciary is not subject to the public records law, or if you're writing about the federal courts, there are often opportunities where the entity or person you're interested in might be interacting with a agency in another part of the government that actually is subject to the public records law. So for example, there's been a fair amount of work done getting public records from public universities, some of which most famously or most prominently George Mason University in Virginia plays a big role in sponsoring and organizing these seminars for judges, which some people have written articles about, some people find interesting. So thinking about the public records terrain, I think, is one thing that could be reproducible.
That's great. Thank you for that insight. It's truly appreciated. I mean, Judge Rufe, don't you have to report, when you speak at a university or travel?
I have to be careful where I say yes to an invitation, because it may reflect poorly on the judiciary if I'm speaking to an advocacy group, say for abortion or gun control. So I can't do things like that. We can't be involved in making political statements just by showing up. We can't be involved in giving the appearance that we're not open and fair-minded in our cases, because what I do nationally or even locally does impact on my colleagues across the federal jurisdiction. So we have to keep our appearances. And even if we're going not to speak, but to George Mason University for their it's actually a scholarly lecture series.
Right.
Many judges, including the deceased Antonin Scalia, liked it. Some judges on the Third Circuit used to go. I've never attended, but I know that there is some difficulty with explaining the attendance there, that if you have a particular kind of case may be a problem. So I tend not to do that. And I tend to speak where I think it's safe. And I don't have time to go to a lecture that just for the pure enjoyment of it, I'll be honest with you. So bully for those judges that can take the time.
So, oh, sorry.
Go ahead. Go ahead.
I was gonna say, oh, go ahead.
Oh, no, I was just going to add, I mean, even though we ended up writing a lot about Justice Thomas and Justice Alito and were accused of being partisan hacks, we looked at, we did some reporting and looked at the, Democratic appointed justices on the Supreme Court, and at least at this point didn't find anything sort of analogous. But there have been very interesting controversies over the years involving, the liberal side of the court. For example, there was a kind of mini controversy 20 years ago around Justice Ginsburg receiving an award and maybe giving a speech at like maybe it was like a Planned Parenthood, either Planned Parenthood or a related organization, and there was people who said, okay, it was hashed out, was this proper? And there've been interesting scandals going back. The biggest Supreme Court scandal maybe in the last 60 or 70 years involved a justice and his relationship. Justice Fortas in the 60s stepped down after reporting around his relationship with a businessman and a financial entanglement. So it's not there's been scandals and news stories sort of across the political spectrum.
There certainly have been in both progressive, conservative, liberal, all of those types, and it's best just to avoid it.
So Russ, sometimes the reason these are, I guess, there's other statutes that govern this, right? And some are recusal and some are disqualification. And do you want to just give a little primer on that?
The difference between the two?
Yeah, because there is a little difference.
There's a little difference, but the terms are now used almost interchangeably.
Yeah.
Technically, recusal is Judge Rufe recuses herself, or Judge Rufe is disqualified by someone else. I mean, it's disqualification is when someone else orders it. I'm not saying she is in either case, but just using her as a ready example.
Sure.
And then you also pose the question, at least in the materials ahead of time, is failure to recuse misconduct? And it's not. It can be bad, but a recusal decision is a judicial decision, and the cure for a bad recusal decision is an appeal, as opposed to filing a misconduct complaint. There are rare instances in which you can allege that there's refusal to recuse for a bias reason or something else, but typically failure to recuse is recusing is a judicial decision.
And just to interrupt you, sorry, but to clarify, like that, it's that judge that makes the decision, right? You're filing your motion, because I used to be a litigator and I've done this.
Yeah, the judge can recuse sua sponte. I've got a problem here, I'm just going to get off the case. Or the parties can file a disqualification motion. No one else can. You can't walk in off the street and say, I think Justice Thomas ought to be recused, so I'm going to file a motion. You can complain about it, but that's a different matter. But then it is the decision for the judge to make. Now, that's not always the case. For example, in Texas, the Texas Supreme Court provides that when a recusal motion is filed against the justice of the Texas Supreme Court, the justice either grants it or it goes directly to the other members of the court, and they decide it. Our Supreme Court is, without naming the Texas, has said, well, that will never work here. I don't think they've explored it very much, but I mean, they've been rather uninterested in alternatives. But the point I'm getting at is recusal is appealable, but it's not appealable on the part of Supreme Court justices, because as we know, there's the only court higher than the Supreme Court is a basketball court in the ceiling.
So, but there is so that's the recusal method we've discussed. But there, I guess the other question I have for you is, like, what is the process of of filing a complaint about a judge, right? Because people don't understand that, and often that can be abused, because as we know, litigation has two parties. One side most frequently is disappointed and one side is, pleased, so that sometimes the party that's disappointed can files complaints. But what's the process? I guess just a general concept of what's the process to file a complaint, and then that is appealable, right? Or not appealable, but there's a process, right?
Yeah. Well, let me use the federal. I mean, obviously, it's going to vary from state. Every state has a judicial disqualification mechanism, either one-tiered or two-tiered. They're centralized. The federal system is different, and it's decentralized in the 13 circuits. But basically, the federal statute provides that anyone can file a complaint. The grounds of the complaint are alleging conduct. The phrase is conduct prejudicial to the effective and expeditious administration of the business of the courts. The complaint is basically filed with the chief judge of the circuit, and the chief judge, once receiving the complaint, can undertake what's called a limited inquiry, can look into it and see if there's anything there. And if you've looked at the data in the administrative office reports, almost all complaints get dismissed at that point. Many of them relate to the merits of a decision. They're basically an attack on the decision. A lot of them filed by prisoners, as a matter of fact. And the statute's very clear that a merits decision, a decision made by a judge in the course of a case, is simply not cognizable. If, however, there are facts reasonably in dispute, the chief judge is obliged to appoint what's called a special committee, an investigative committee composed of district and circuit judges in equal number plus the chief judge, who undertake an investigation. These can be quite elaborate at times. There's maybe 3 or 4 special committees nationwide a year. And the special committee makes a report to the Judicial Council, the statutory body that exists in each federal judicial circuit, composed of district and circuit judges, chaired by the chief judge, makes a report to the Judicial Council, and the Judicial Council can do one of a variety of things. Cannot remove the judge from office, that would violate the Constitution, but it can recommend a private censure, it can recommend a public censure, it can recommend the judge take certified disability, the judge be removed from the caseload for a while for remedial purposes, can order the mechanism to go in place to remove from office a magistrate judge or a bankruptcy judge, because they don't have the Article the good behavior protection of the Constitution. The appeal then can go to the Judicial Conference of the United States. Final appeal, and the Judicial Conference of the United States can make a decision to refer the matter to the House of Representatives, saying there may be grounds to impeach the judge. Now that occurred a couple of years ago. Two judges in the Fifth Circuit, one in Louisiana, one in Texas, in which the conference recommended impeachment. One judge was impeached and removed in Louisiana. The other one resigned rather than go through the impeachment. Now, the mechanism is that I described is obviously different in the states in the particulars, but the basic idea of a filing, an initial review, dismissal of frivolous or merits complaints, and then for the few needles in the haystack, go through a investigative process, and then a decisional process where there can be a hearing. The federal statute provides protection, counsel and right to be heard and notice all the way through.
So it's interesting because just as I was doing research for this panel, right, just this month, the Ninth Circuit, issued a recent decision. The Judicial Council of the Ninth Circuit issued a recent decision. And so I thought it was interesting because it looks like the initial complaint was filed in November of 2022, but yet it wasn't publicly disclosed because it's, there has to be an investigation. It looked like there was an extensive investigation, and it actually wasn't made public until this month. And this was, I would say, it was pretty extreme situation, and the judge actually resigned before any action was taken. So I would like to say, sometimes that doesn't even get out in the public, because if the judge resigns, then then the Judicial Council sometimes decides that there's no need for the public to know about all this information. And I'm wondering, and Justin, I don't know if you have any feeling on this, but that there's been so much more interest by the public and the press, I'll say, in judicial conduct. Do we think that this accountability has contributed, or maybe even contributed? I know none of you know the facts, so I'm contributed to this Ninth Circuit's decision disclosing this judge's conduct?
Well, I think it's required to be disclosed at the point of a decision. And the decision
if
is made.
If it's a public censure, if they clear the judge, it doesn't have to be disclosed.
Exactly. But
in Pennsylvania, let me just say, in Pennsylvania, once that investigation began, once it moved beyond the non-frivolous stage, that would have become public much earlier.
Right.
But in the federal system, this is clearly what's happening. Although the latest news about that case is that there's a question being raised about why the public didn't know it sooner. And that's because of the system in place. But honestly, it's bigger than just the motion. See, there's three things going on here. There's a recusal that a judge can do herself. There's disqualification motion because of alleged bias or some other kind of misdeed that normally goes through the circuits pursuant to the judicial, the act in particular. But then there's this other area, and it's not a gray area, but it's the public's right to know, because this judge is accused of sitting on cases where he was still having various liaisons with people that were handling the cases, attorneys, both sides. So I don't know anything more than what I'm reading in the newspapers, and I'm not speaking to the case and judging it. I certainly am not commenting on it, but it's an example of how there can be more than one motivation to have an inquiry, and how that inquiry is handled is pretty much charted out in the regulations that go along with the Judicial Conduct and Disability Act. But it's difficult no matter which avenue there is. But the Ninth Circuit did make this public when they were finished their job, and it was referred to the Judicial Council, the Judicial Council Committee, so that it was now what? Impeachment. They went to the House. I don't know what's happening there, But will that matter? Because he resigned already?
He resigned, right? So I'm not sure, but just,
I think there is a question, because the timing of these alleged misdeeds and its impact on the rest of the orderly administration of justice could very well be impacted, and it could very well be sometimes, something's not really moot. So I don't know what will happen,
interesting.
but it would be a first.
Yeah. And Justin, do you feel that the interest by the press, right, in judicial accountability, I'll say, has increased, not just of the justices, but just of the court system in general, and is it also because I'll say the public is now more aware of the court system and the judiciary?
Yeah, it's a good question. I honestly don't know. My operating assumption is always that my stories will have absolutely no impact on anything. So unclear. But I think in this Alaska case, that does bring up another sort of reporting tip, which is, and I don't know about this particular case more than I've read in the press, but this was a case where I think if you were a reporter up there and were trying to make a beat out of covering the courts, or if that was part of your beat, I feel like you would have gotten a whiff of this because it was so egregious, or like the allegations at least were very lurid, sexual misconduct. And if you had been, for example, calling clerks after they had left, 6 months after they had left the judge's chambers, I feel like there's a decent chance that you would have gotten onto this before this public report came out a few weeks ago. And I think we've seen examples of that in the kind of peak of the Me Too reporting. There were several cases I remember involving federal judges, including a judge in California whose name is escaping me right now, where there was
Judge Kaczynski,
where there were big public kind of or where there were big journalistic investigations based on people coming forward. And I think, it was in my experience reporting on the Supreme Court, I mean, actually, candidly, when we first started that reporting, we were originally thinking, oh, like the clerks, they'll know everything. And, ultimately, we did talk to a bunch of former Supreme Court clerks. There's a lot of them. I mean, they change every year. Each justice gets I think 4 or something like that every year.
Oh, no, 6 or 7.
Oh, 6 or 7. Okay, interesting.
Yeah.
I always remember that I think it was Justice Rehnquist would only take 3 because he wanted to play doubles tennis, and so he needed play with himself. So that made the even 4. But anyways, there's a lot of people that are clerks, and especially if you're writing about something that happened 10 years ago, some of those people are like law professors now, and some of them talk, some of them don't. But turned out for what we were reporting on, the clerks really didn't know much because they just knew about the justices' professional lives. But if I were covering a court or a court system as a beat, I think it would be, like any other beat, there's a universe of people that know what that know things sometimes of what's going on at the court. That could be clerks, it could be the permanent staff, it could be attorneys that are regularly at the court, and you want to make it your business to try to talk to those people, and I feel like that's how you hear things.
Justin, you mentioned before that you go to other agencies that aren't FOIA, that are FOIA allowance, and the DOJ is one of those agencies. To a certain degree, you can use a FOIA there. I've had enough case spiffs on it, but nothing for this kind of lurid behavior that's alleged here. And it's interesting because so many of the alleged complainants, alleged victims, whatever you want to call them, were employees of the DOJ. That, there's a reporting system there too. And we have law clerks in the federal court. We have a law clerks code, which is very similar to the judge's Article 3 code of conduct. And the canons are identical and the objectives are the same. And we have reporting requirements, at least in the judicial misconduct and disability law that says, me as a judge, if I know about something, even if it's not proven, but if there's reasonable basis for me to find the source credible, I'm supposed to report it.
It's
So
misconduct.
there's a lot of questions that are raised here about how this has come to finally become public. Because
you were-
if
oh, sorry.
I knew about it, I'm supposed to, or I'm committing a faux pas.
Right.
And yet all through the canons, you can't accuse someone else of unethical conduct wrongly. You must have grounds. So it puts, employees in a bind and colleagues. It's just very difficult to deal with, especially when the informal system wouldn't work in this situation in Alaska. But the informal system hasn't worked in the, DC circuit where there's an age issue.
Right.
And that's a very difficult problem to resolve. So, I mean, there are things in place that would help, but somehow or other, they don't always get easily resolved.
Russ, you were going to say something.
No, I just was enforcing her point that
Right.
if she doesn't report it, it's misconduct.
Right. And so, there is this, everybody talks about, well, this is an informal pact, but there are obligations, right? Self-reporting, I'll say self-reporting obligations that the court has. I guess, Justin, the other question I have for you is, how did you decide, or how did you decide on what, because there's a question in the Q&A about who you decided to interview and how you decided to go about this. And I wanted to know if you could just share with the reporters a little bit about that process, and maybe not just about the Supreme Court justices, but any, in general, investigation into a court system which has the limited, I'll say, limited access issues.
Yeah, I'm just reading the question. Yeah, it's a good question. I mean, with my reporting at ProPublica, I think the way I'm thinking about this is because I'm not on this as a beat for 10 years. I'm usually changing what I'm writing about every couple of years. I think about it as sort of a series of, to put it in kind of gambling terms, a series of bets about how you're using your time, which is the only real resource we have as reporters. And so, as I was mentioning earlier, when my colleague Josh and I started doing this reporting on the Supreme Court, and this was not a situation where we decided at all in advance, we're going to spend a year writing about this theme, because we didn't know anything. We didn't have any sort of leads in the beginning. But once we found, we were spending a couple of weeks poking around, developing ideas, for a memo. That memo that we passed to our editors to get their feedback, one of the items was about this Supreme Court justice's travel, but then there were other items, for example, about the appellate courts and some state court ideas also. And then our editors told us, okay, the Supreme Court thing sounds interesting. Why don't we spend a few weeks digging into that and seeing if we think it's worth spending more time on. And that's when we sort of looked at those public records, started seeing these private jet references. And it was sort of only at that point that we decided, okay, we're now going to start, trying to really get inside this world, because the early reporting is always kind of talking to people who are happy to take your phone calls, like law professors and people like Russell, who did help us understand some of these rules over the course of this reporting. But the kind of revelations about these gifts, and it wasn't just travel. It was ultimately found, for example, Harlan Crow's billionaire was paying private school tuition for Justice Thomas's adopted son, or not formally adopted, but essentially adopted son. And so that information, is not in any public record. That we got from having a spreadsheet of 200 people who we thought might know about this and calling all of them. So kind of like a lot of this type of reporting is really a numbers game, and you have to, if you call 50 people and 4 or 5 people talk to you, then that's like pretty good. So a lot of it's getting used to people saying no to you and telling you off, basically.
It's interesting because the prior panels we have had a few judges on and a few reporters or lawyers turned reporters, and everybody emphasizes, first get a basic understanding of the law, right? So here, right, get a basic understanding of what judges are required to report, or how they're what limitations they have, and that in essence helped you, right, formulate your approach as well, because there is this difference in reporting requirements between the Supreme Court and the rest of the judges, and so getting to have a basic understanding, right, is really crucial to conveying to the public as well what's being done and what isn't being done, I'll say. We have go ahead.
Oh, no, I was going to say also briefly, and I'd be curious what Judge Rufe thinks about this, but we actually had some luck talking to retired federal judges to get, there was cases where we wanted to go beyond the kind of like ethics expert who is not a judge, where we wanted to talk to actual people who had been federal judges to ask, like, what would you do in this situation? What do you think about this? Does this shock you, or does it seem normal? And so we were actually surprised by how many retired federal judges were willing to, take our calls, not always being quoted, but.
Were those retired judges who had actually given up their commission because they were working? Or are they retired judges from the judiciary because they still have a conduct code of sorts to comply with? Not that anything much could happen.
Yeah, I don't actually know. I'm not sure I understand. I don't think I understand that distinction. But also, I mean, would it be, I mean, I don't know if this can be answered, but if a reporter or somebody was asking a judge, not to comment on a specific fact pattern, but, a question like, if a lawyer wanted to pay for your lunch, what would you do? Like, would it be kosher to answer that, or no? I don't know.
Oh, sure. I mean,
Yeah.
well, that particular example is pretty easy. I went through a campaign to become a state judge, and I wouldn't take any donations from attorneys. Back in the day, you didn't need that
but
much
that's
money anyway.
unusual.
I just wouldn't. And no, they can't take me out for lunch now. So
and by the way, that's what we found. We heard that, again, this was across the partisan spectrum. We heard very consistently from a number of retired federal judges that they just wouldn't go anywhere near accepting even very modest gifts or like a lunch from anyone who was anywhere close to their universe, because it just wasn't worth it in terms of their reputation.
I keep thinking that every year I should have several garage sales just to make money to take my law clerks out and my former law clerks out, because, it does get pricey. But I really feel uncomfortable because they're working or associated with clients or working in law firms that may be appearing in front of me. So none of us needs that grief, even though we know it would never come between me and doing the right thing according to the facts and the law. I think it's just that appearance of impropriety again. The accusation is bad enough. So I have said this often. When I became a judge the first time, 1994, in the state, I knew I was giving up my constitutional rights. One, I was giving up my right to have an opinion and voice it, a personal opinion.
Yeah. And a lot of friendships, and it's
I gave up,
and right, I know, and
I
it can
gave
be
my friends
lonely.
the choice.
Right,
I
yeah.
said, some of us go back too far, so you're never going to appear in front of me. And some of us, you've been great, loved working with you in the PD's office, loved this in private practice, but you've got to choose now. You either continue to be social with me, or you can enter my courtroom, and you can't do both. And they made choices.
So we are at our time limit.
Oh,
I
so
want to,
soon.
it's so soon. And I want to thank you all. This was, again, a great way to conclude this program. I want to thank those who have attended. We will be circulating information to attendees with a list of resources, like, for example, even the statutes and laws that we've referenced. And so if anybody has any questions, please don't hesitate to reach out to us at PMC, www.pmconline.org. And these programs will be recorded and you'll be able to share them. So please do that. And thank you all very much and have a great day.
Thank you very
Thanks,
much.
everyone.
Bye-bye.
Bye.
Pleasure being on your panel.